price per acre 72,900.
Which
Clearly shows the 72,900. Even the other exemplars also show 61,500, 60,000.
Yes, ma'am.
41,000.
yes, sir.
Totally erroneous.
One of the reference court has considered page 106, the same sale instance. Somit, correct me if I'm wrong, please.
It is at page 106 of the reference court's order, and the exemplars prior to the notification are 1, 2, 3
Till 6.
till 6.
What is the date of the notification?
July 1990.
All of them are prior to that.
Prior. Malaj, 7 to 10 are post the notification, and that's why the
And
reference
it is also not as if that it is for a small plot or something. It is for 96 R.
Yes, sir. 1 acre.
Malaj, the acquisition of MIDC is for a much larger area, and these exemplars which have been cited are for a smaller.
It's not a
area.
smaller area. It's the largest amongst all the exemplars.
Yes, sir.
My lords, it's 96 R, whereas the acquisition is for hectares.
We know that
My lords.
you can't have an MIDC on 1 hectare.
My lords, but the reference code has averaged the sale price as well as the averaged the sale instances and given the enhancement, my lords. That is what
It has to be on the average, or it has to be on the
My
basis
lords,
of the highest.
my lords, there are judgments of your lordship's court which say that if it is of
Unless it is shown that exemplar was malafidely done with an intention that somebody gets a higher compensation.
my lords, because out of the 10 exemplars, which were 9 exemplars which are relied, this was the only highest, and it was 2 kilometers. My lords, it was 2 kilometers away from the land acquired.
Where is the finding to that effect?
I'll show your
I think it's
lordship.
contrary. That-
Where is the finding to that effect? File your written submission.
My lords.
Para 29 is the findings in the reference court's order relating to the distance.
Yes,
So we'll find.
the High Court only observes that the reference court has considered. So where is the consideration by the reference court? You point out to us.
We'll do that, Malaj.
When will you do that? You are supposed to do it right now. That you are not doing it.
My lords, my lords, we showed that page to your lordship's court, page 96, I believe. I'm sorry, 106. My lords, 106. Page 106. My mistake. My lords, it's already relied by the reference court.
Please, madam, you is referred at serial number 4.
Yes.
If the learned reference court wanted to ignore it or not take into consideration, it should have given some reason as to why it is not found to be bona fide sell transaction. Where is the discussion to that effect?
Contrary, your lordship, the reference court has found it to be bona fide
Where is that?
transaction. Yes, para 30 on page 116. Last 9 lines of para 29, Your Lordship. The claimant's petitioner have placed on record the certified copies of sale deeds which have got presumptive value under Section 51A of the Land Acquisition Act. After placing certified copies of the sale deeds on record by the petitioner, no rebuttal evidence has led by the respondent state. As the sale instances covered under the sale deeds are came to be effected in due course of business in routine manner between the willing purchaser and seller, therefore the transaction covered therein can be relied upon and acted upon to determine the market value of the land.
No, my lords,
And the very-
this finding is found because there were counter appeals filed by the state as well as that of the claimants.
Which were
So
disposed.
therefore, the reference code should be point out as to why if the sale instance number 1, 2, 3, 5 are considered, then it shows.
The very next para, serial
My
number 4 not considered without any reasoning, Your Lordship.
Yes, my lords, 31 says that if the sale instance at serial 1, 2, 3 and 5 are considered, shows the price of land sold under sale deeds was around 40,000 per acre, that is 1 lakh per hectare.
So he is claiming on the contrary 80,000 per hectare.
72,900 per acre, 1,80,000 per hectare.
To give us sufficient plus for order.
Other fresh matters may be listed next week or after the judgment for.
After बाकी दो इसमें issue notice renewable after 8 weeks. File your sufficient by Monday.
Lord,
Grateful, my lords.
obliged. Your Lordship.
Yeah, please. Please, your lordships, I appear for the petitioner. The parties have reached an amicable settlement, your lordships. For that reason, the TP has been rendered infructuous and we seek to withdraw.
The petitioner states that subsequent to the filing of the petition, the matter has petition is therefore rendered infructuous before.
Grateful, your lordship.
Please, your lords.
Yes.
It is the case where, my lords, the father sold his property and his son's property to his brother. Then after, when the son was a minor, then son after becoming major filed a suit for partition simpliciter. Then the suit was disagreed and the defendant went to appeal confirmed the suit. In second appeal, there is a reversal on finding saying that the suit for simpliciter is not maintainable. The suit to set aside the sale deed or the conveyance deed has to be there. That form of the suit should be that the conveyance deed which executed the minor's father should be set aside. Only then the partition suit is maintainable. That is the finding given by the second.
What was the suit for?
Suit for partition simpliciter. It is not for setting aside the conveyance deed. The court says, the trial court has held on finding on fact is that it is a void because it is not for legal necessity and not for any pious debt. So therefore it is a void. That was the finding of the trial court as well as the first appellate court. The High Court did not reverse on this finding on fact. The High Court only on the issue of law. They said that suit for simpliciter partition is not maintainable without setting aside the sale deed. My lord, my submission is.
So whether you had implicated those third parties in who?
No, third party is not here. This is the.
No.
I'm sorry.
If you are filing a suit for partition,
Yes, my lord.
in the suit you also claim partition with regard to a property
Please, my lord.
which is already alienated.
Please, my lord.
Do you also implicate the party in whose favor the rights have been created?
Yes, my lord. Yes, my lord. My lord, in this case, the who is the receiver, that the assignee of the property is one of the co-parties. Therefore, he is not a third party, as we call it. He is the party to the partition. So therefore, it is an incidental during the partition, the court to decide the antecedent title of the property. My lord, if the suit for setting aside the sale deed is necessity only to bring back the property from to the Hindu joint family to make it available for division. Supposing the property is sold within the family property without disturbing the sale deed, the partition can be taken place. And my lords, here what had happened in the trial court, there are two shares were sold in the deed. One is the father sold his share and the father sold his minor son's share. The court did not disturb the father's right to sell his property. The court did not disturb the father's right to sell the property. Court says that father has no right to sell the minor's property because there is no legal debt. Therefore, the partition was given. My lords may kindly consider the findings, my lords. Then, my lords, last hearing I have given the propositions.
Your father has disposed of the properties.
Sorry, I'm sorry.
Third party rights are created by your father.
I may not use the word third party. Though he is an assignee, he is the party to the suit. Third party will come only if the property goes to out of into joint family.
So in whose favor the rights have been created? In whose favor the sale deed is executed by your father?
My uncle, my father's brother, real brother. My lords may see the
So
map. My lords,
your father has created rights in favor of his brother.
yes, brother. My lords may see this. My lords, my client name is K. Tangavelu. He is the plaintiff. His father is U. Krishnasamy. He is the defendant number 2. His brother is U. Palanisamy. On behalf of the assignment deed was executed in favor of U. Palanisamy. My client filed a suit for partition of a Hindu joint family against U. Palanisamy and U. Krishnasamy. And the court did not disturb the assignment deed, which uphold that U. Krishnasamy has a right to sell his own share, but he did not have the right to sell the property of the K. Tangavelu. That is my client's property. Therefore, there is no legal necessity to set aside the sale deed and the part. Let's I have given the proposed. Next page I have given the propositions.
Yes.
The power and authority of the father to dispose the ancestral property of his son is only to the extent of pious obligation and debt benefited for the family and necessity. The disposition of ancestral property of the son by the father is to be considered as one co-partner disposing the other co-partner property, except as otherwise, other than pious obligation and debt benefited for the family and necessity, the disposition of the son's property by the father is void. When the transfer of interest in one co-partner's property to another co-partner, the Hindu joint family property is not destroyed, but it is intact. Hence, the suit for partition is maintainable without recourse to set aside the transfer deed. Where the purchaser of the co-partner interest is a stranger, it is imperative to set aside the sale for the purpose to establish that there was no severance of joint family and to restore the antecedent title, enabling to seek partition.
what about limitation?
My lord, when there is a limitation will come only if it is avoidable. If it is a void, suit for partition is maintainable because the limitation has no role. Because suit for partition,